All right, we are here in Columbia, South Carolina. Andrew Davis, as the next step in the Alex Murdaugh saga. The hearing has ended after just under 3 hours of questioning from the judges, as well as testimony from both prosecutors and defense on this side. Now it's a waiting game to figure out exactly what may happen next and if Alex Murdaugh will get a new trial. Much of this was sort of a greatest hits of everything that was going on. We heard a lot about cell phone evidence that led to his conviction, about everything that happened the night of the murder down to the various minute. But there was also a lot of testimony about what happened after the trial, specifically with jurors that were either pushed off that jury or had questions because of what former Colleton County Clerk Becky Hill said to them during the deliberations or after. Hill, of course, has now pleaded guilty since to misconduct in office, but not jury tampering. The defense certainly is pushing on that in all their briefs and in testimony right now to see exactly what they could get from the situation. The justices had many of those same questions about Becky Hill's testimony, about the egg lady who was one of the last jurors kicked off that jury right before deliberations started, and why her testimony was so strong, yet not initially admitted into record as a witness during the last appeals hearing. So they wanted to know more about that, as well as juror Z, who was another one who had some contradicting testimony during that appeals hearing, but still said that Becky Hill talking to her and what she said to her did affect the way she was potentially voting and how she dealt with everything in that verdict when it came to convicting him. The defense was very specific. They said the financial crimes evidence should not have been involved to begin with. There was way too much of it. 12 days by the time they were finished. They said it probably could have been done in an hour and a half or 2 hours, one of the justices said to prosecutors on this one. But the point was they wanted to put it in there as motive. They wanted to make sure that everyone understood that Alex Murdaugh had done these things, that the walls were falling around him, and that he felt this was his only way out, was to kill his son, to kill his wife, as they were trying to determine exactly what was going on and how he was spending this money, what he was spending it on, which turned out to be drugs, and how they made know that there were some major financial problems coming, as well as major problems in general for that family from all the money he was stealing from his clients. I've got my legal expert, Joe McCullough, who's coming on with me in just a moment to break down a lot more of this than what I have. But I can tell you, after watching 6 weeks of trial from Walterboro, a lot of these same issues came up, this time, though, much more targeted by both sides. The defense wanted to make sure they got their point across, that Becky Hill lied to everybody while she was there, and then she talked to these jurors. She tried to do this to poke the jurors and push them in the way of a guilty verdict to improve the chances of her book being a bestseller. It was very clear they'd like that, and they believe that is reason enough for a new trial. The financial crimes evidence, also an important reason for a new trial. Way too much of it. It may have been brought up initially as one motive or as a system there, but to go through 12 days and to continually show that Alex Murdaugh was a quote-unquote bad man, the defense said there's no chance that needed to be done in this case, and they believed it was overkill, it was too much, and it affected the jury on a much deeper level that led to this guilty verdict that the evidence, which they really did not have, actually never did in this case. So very interesting to see that side. They didn't believe the evidence was there, and they dealt back into some of that evidence. When they went back into the cell phone records, how it was just minutes after everything was going on, that Maggie's phone was still operative until a certain point, and the orientation of the phone, that it didn't light up necessarily at the spot off property, off the Moselle property, when Alex drove by and would have to throw it out of the window, and at about 40 miles an hour, and it would very clearly orientate and turn on then. The defense saying this is a very clear showing that Alex did not throw that off of there, and that Alex was not involved in tossing aside that cell phone to try to hide it in some form. At the same point, they didn't have direct answers for everything that was going on in the kennels, that everything with Alex Murdaugh's time there, but instead they just don't believe that the prosecution did enough of a job, did their job properly to try to go ahead and get this conviction and make the evidence stand for itself. Instead, the financial crimes evidence and proving that Alex Murdaugh was a bad man, dozens of clients that he stole from, millions of dollars that he stole from people, was enough to say that he could have committed these murders, and that the evidence they had was not strong enough to make that work. Our legal experts out here, all of them were talking about it. If you look online, several people, including Eric Bland, who represented the Satterfield family, who were some of the biggest and first victims from Alex Murdaugh, said he actually believes these justices will be 5-0 in favor of giving Alex Murdaugh a new trial from what he heard there. But I've spoken to several people who aren't so sure about that. The questions come up, but there are voluminous amounts of briefs, page after page after page, hundreds of pages, if not thousands, detailing exactly what they say are going on and what may happen. So that's the question that still has to go on. It's not just the questions that happened here, but it's all the briefs that are on paper that are in front of them that they're going to look at in depth over the next potentially 60 to 90 days as we do this. I'm trying to bring in Joe McCullough if I could here. Joe, come on over for me. You've got a lot of insight into this. You watched the whole trial in Walterboro and sat down here. Your impressions first, I guess, of the judge's questions in this case and what they were concerned about.
Well, Andrew, you can't always tell from the questions what they mean, but today certainly seemed like a good day for the defense in this case. The inquiries and arguments focused on the failure of the motion for new trial on jury tampering. Why was the lady, Miss Crosby, who is my client, who's been called the Egg Lady, a name I'm sure she'd like to shed, why her evidence was not admitted. This court seemed to suggest that they intended to consider her affidavit, which is quite damning and is corroborated by multiple jurors. And so that in and of itself, frankly, in the questioning, even Mr. Waters conceded that essentially that if that affidavit were true and were included in this fact picture, it would be so egregious that a new trial might not be able to be avoided. And that's my paraphrasing.
Of course, and that's your client too, but we're talking about it. Why wasn't her testimony included in that first appeal specifically, since she seems to be a huge focus of the South Carolina Supreme Court?
It was a mystery to me. But I think that what this court recognized, and we gleaned from their questioning, is that it's a mystery to them as well, because Justice Toll's stated logic during the hearing was that she was not, because of her exclusion the morning that the case went to the jury, that she was not a juror who participated in rendering the verdict. And yet the court found it significant that the alternate juror, the person who sat on or as a member of the jury, but only as an alternate, and then did not participate in the jury verdict, was allowed to testify. That was an abject inconsistency that seemed to concern the court.
Yeah, talking about that juror Z, who seemed to have some questions about her testimony and all this as well. The financial crimes, though, obviously were an important part of all this. Even the justices said to Creighton Waters, I thought was very strong, you took 12 days to go through financial crimes evidence. We could have done this in about 2 hours instead.
It could have been done in that span of time. Could have been done with one witness, which occurred to me, and as we were sitting in the audience during the trial, it was a mystery why the court allowed days and days of collateral testimony. This was a murder trial, and yet we spent 6 days, 10 witnesses, hours and hours and hours on, and the Chief Justice was very concerned about what he referred to more than once as the granular and nature of the witnesses who were permitted to testify about this financial evidence and why that was necessary. A little dab will do you, but I think that's another significant issue in this case.
Yeah, absolutely. It seemed like they were focused on that. We can't get away from the minutia when it comes to cell phone data still, though we went through it days and days in court. I don't know if that made an impact, but it felt like no matter what they did, the financial crimes, and specifically Becky Hill's admission of being a liar in this case, as they said in that court, really made an impact on these justices.
Well, I mean, when she entered a plea to perjury, she is now, sadly, a confessed perjurer, liar, to use a harsher term. That was not a fact that was recognized except by Justice Toll, who found that she was not credible, who found to the contrary that other jurors were credible. And so I think the court's got a very difficult task in finding a way. I think they have a difficult task in finding a way to deny a new trial.
Yeah, the biggest thing they said to me, too, is everything that went on, they seem to be leaning in that direction. There's no question. But you said don't take their questions as gospel necessarily. Just because they're asking them, they still have paperwork in front of them that could say a completely different story.
Well, and they're looking at the case law and they have to decide in this somewhat unique case, made unique only by the international acclaim. They've got to decide what the standard is by which you judge jury tampering. There's a lack of clarity about that because here we are arguing two sides of that coin. So I think the court's going to have to find its way to declaring as a precedent what our standard's going to be going forward. And that standard will either benefit the prosecution or it will grant a new trial to Mr. Murdaugh.
And you do expect a new trial, 60 to 90 days? We expect a decision, probably? An opinion.
I'm hoping for that, I guess. There are more than 7,000 pages of transcript, exhibits, evidence. It is a monumental task for the court. So, and obviously, in a case that was given 20 minutes, and 10 minutes of argument, we're just now leaving after, 3 and some hours. So that's a challenge. They have other business. This is not the only case in South Carolina.
And you've got a lot to talk about with your client now, too.
Well, I've spoken to Ms. Crosby this morning. I told her to expect to be a significant factor, and sure enough.
And she was. Joe McCullough, thank you so much for your insight. I appreciate it. So we are here in Columbia, exactly. So it looks like the justices took their time, nearly 3 hours, to go ahead and talk through everything, ask the questions they needed to. Now it's a waiting game to figure out exactly when they will make this decision and if Alex Murdaugh will get a new trial. Expect that in the range of 60 days or more before that decision comes. In the meantime, we'll break down everything you had here today and tell you exactly what you need to know when it came to what happened inside the court and what happens next tonight on News 3 at 5 and 6. In Columbia, Andrew Davis, WSAV News 3 on your side.